Well, good morning, everybody. Welcome to Wednesday and the Infinium HR 2026 Labor Law Update and HR Success Roadmap. I think I had my sound unmuted there for a little bit, so you may have heard the beginnings of preparation of sliding my microphone into place and coughing a bit, so I do apologize for that. But we do have a pretty good group on the call right now, or on the webinar, so thank you guys for showing up today and getting a little bit of information on what's happening in the world of labor and HR. So we're pretty excited to provide this to you, and thank you again for showing up. Hope you got your coffee here. I was going to start a poll and see if like what everybody do. We like coffee in the morning, or are we tea people? So maybe put that in the chat. That might be kind of a fun little unscientific poll. Okay, so let's get started. I'm going to jump right in because I don't want to take too much of your time, and a couple folks will be flowing in here as we go. But you know, every year we do this, and we really try hard to what I feel is kind of bring down all the legal aspects of what these these new labor laws have in place. Kind of include enough on the legal side that we need to know, but without flooding you with legal information. Like on one of these slides where we've got, just a few bullet points, I looked at a lawyer website on it, and it was, a giant, huge page of all this information that probably you don't need to know. What we really want to do is like, what do we need to comply? How's it going to affect our business? Do we have to update our handbook or policies or postings? What do we physically need to do? And then how do we maintain compliance in the future? And I want to say this is kind of a surprise here in California. This year, it's a pretty light year. We've kind of dodged the bullet, I guess. Last year was massive with just dozens of changes, big stuff. This year, there's really not too much. It's a lot of little slight nuances and changes in the laws. There's one fairly big one outside of minimum wage. But really, other than that, it's not too bad. So I'm going to try to get you through it. And hopefully this will help you make sure that you're in compliance coming up the next year. Okay. So what we're going to cover is we're going to go through the key changes. There's about, 7 or 8 of them. And hopefully that will give you the gist of what's going on. We're going to talk about what impacts employee handbook. There are just a few things that really do change it this year. Oh, sorry, my watch keeps banging on the table here. And if you're a client of Infinium, I haven't checked the roster here, but if you're a client of Infinium, HR client, then we are going to be updating that handbook with those laws here. We're working on that now. And then you're like, what do you need to do proactively to make sure that 2026 is smooth? We've really experienced a flood of employee issues lately. And I think one of the biggest things that we'll talk about is that employees that just seem to find a loophole in your policy or your practice, and they take advantage of it, and they end up causing a lot of trouble when something in the beginning that maybe could have been handled a different way, and it just goes south because they just find a way to make things difficult. So we're going to talk a little bit about that. And then finally, like what do you get when you do the right things with HR, with practice, with employee management, with culture, all those things that we have to do as a business, especially in California. What do you get out of that? But so it's not too complicated. We'll keep it as concise but simple as possible. How's that? Okay, so let's look at the key changes for 2026. This is the big picture. We know California is constantly expanding employee rights, and it's no different this year. It's a much smaller incremental move, but certainly always in the favor of employees. We see that happening, just every single year. It just gets more and more and more, and that's fine. There's some things that are wonderful. There's some rules and laws that are wonderful. There are some that are very burdensome for employees or for employers. And we have to try to figure it out because we don't really have a choice if we're going to do business in California. So it does definitely, there's some increased documentation, there's some notice requirements. There's a greater focus now on pay equity and record keeping of your pay ranges, your positions, and how you hire. to make sure that you're not discriminating against gender or race or identity or any of those things. So they're really starting to push that now. That came out about the whole pay equity law came out about a year or two ago, and they're just tightening that up now and expanding a little bit. So that's something you have to think about. And then employees, again, we're going to talk about this, employees exploiting the loopholes in policy and practice. It is what I believe is one of the most dangerous things going on right now for an employer, because when employees do that, they just sort of keep pressing the issue, and somewhere along the line, the employer is going to get frustrated and is going to do something wrong, is going to take the wrong step. And that one wrong step, lands that employee in front of an attorney, and pretty soon you've got a lawsuit where they're throwing everything but the kitchen sink at you. And I've seen it happen way too often lately. And there's plenty of plaintiff attorneys out there that just stand in the ready to file extortion lawsuits, because it never really goes, rarely I should say, and I may have some attorneys on here today, so I know you guys go to court, and more often you go to mediation for a settlement. So I've said this before, I'm going to keep on saying it. The attorneys will throw everything but the kitchen sink, including wage and hour, discrimination, retaliation, whatever they can kind of surround that employee with. And it's enough that you're never going to try to defend that, because even if you defend it, you still lose with attorney's fees. So they're going to throw everything at you and get you to try to settle for an amount that is somewhere between probably $20,000, $30,000, $40,000 and $150,000. That's a pretty good number for a few hours of work on their part. So just know that's just a fact of life here in California. And unfortunately, we can't just do business the way we feel it should be done. We have to always be thinking of, okay, how is this going to look in front of an attorney should this go wrong? So just be thinking about that. And then the bottom line, even if your handbook is legally updated and your policies are good, your practices still matter. I've seen some things lately where the handbook is right, the policy is right, but managers or the owner of the business is not actually following the policy. They let something go by, and that ended up turning into a big problem. Had they just followed their own policy and been educated, or at least aware of that policy, so they can act on it, then things would have been, would have probably gone a lot smoother. So that's just something to think about, is that really be careful about knowing your handbook and then being able to put those things in practice. Okay, so number one, as always, in California, our minimum wage is going up. What changed? Is going up to $16.90 an hour on January 1st. Now, that is not the certain counties and cities, LA, San Diego, San Francisco, Berkeley. Those folks are probably, I think they're in the 17, 25, 40 range. We'll send out some information. So just know that if you do have employees that work in those areas and you happen to pay minimum wage, then you've got to pay them the higher minimum wage. We have several restaurants that are in the LA area, and they have to figure out whether they're on the city line or the county line, and then adjust their minimum wage to match that. So just know that if it doesn't affect you, then you are at $16.90, and that's the way it is. Now, that also impacts the exempt salary. Minimum this year is going up to $70,304, and so if you do have an exempt, a qualified exempt person, then they're going to go up to $70,304. And there's a whole bit of information on whether or not somebody's exempt or not. So if you're in question with one of your employees, they don't really fit one of the obvious exemptions, being a manager, being like a controller of your business or a major function of your business, or being an outside salesperson. Those are the general big three. If there's anything that that you feel is not right, please give us a call, and we want to help you to make sure that's right. But just keep in mind that I'm going to go down to these next ones anyway. So again, review the exempt, non-exempt roles, adjust your salaries. Now, this is where I want to stick on this: adjust salaries. Now, you may have employees that are sitting now at $17 an hour. So those employees probably need a raise too, right? So this sort of pushes the whole bottom end of the pay spectrum up a little bit. So just make sure that if you've got an employee that has been sitting at $70,000 a year, and all of a sudden now are you going to raise them to $73,004? And the person that was at 68.9 is also going to 73.04, or are you going to, bump them up, commensurate with that ratio? So something to think about. Does affect everything. Does this affect your handbook? Not really. It's not really a mention in the handbook because it changes so often. We don't put that in there. So that's that. So this is the biggest one probably this year. This is a Workplace Know Your Rights Act, SB 294. And this just means that you've now got new posting and notice requirements that are going to come out that are basically a written employee rights notice. Must be given at the time of hire and annually to all employees in your business. Now, most of this information is probably in an employee handbook, maybe some of it not, but they want to make sure the companies that maybe don't have an employee handbook, that employees are getting these rights. And I pulled this. Let me go to the next slide here. So they do have an opportunity to designate an emergency contact. Again, that's something that is usually in most employee new hire packets. But there are some strong anti-retaliation protections for that employee if they do complain or file complaints or lawsuits or whatever about the that involve their rights, especially those on the notice. And then let me stop there. So let me tell you what the notice says. I get a little ahead of myself. I made some notes here. This is what it includes. I pulled this from an attorney's site just this morning, actually, just so you know exactly what's in it. And it's not done yet, by the way. This will come out in January 1st. It should be out, so we don't have access to it yet. But it's workers' compensation benefits, including disability pay, Medicare for work-related injuries or illness, and contact information for the Division of Workers' Compensation. A summary of employee rights to immigration inspection notices and protection against unfair immigration-related practices. Now, this is what I feel was the gist of this, and the reason why it was put in place was really, really specifically because of, the Trump administration now is really, really ramping up the immigration enforcement, and they're out there at workplaces, especially in some of the big cities, LA, obviously California has several. So I think this is the biggest thing, but they also did include a couple other things, I think, to sort of balance it out. Union organizing and concerted activity, and then constitutional rights during interactions with law enforcement at the workplace, including Fourth and Fifth Amendments. So two of the four major items in there are really immigration related, and so that's pretty much the reason for this, I believe, and that's fine. I think everybody should know their rights, and whether you agree with the whole immigration, crackdown or not, then this is just, it's right down the middle. Employees need to know their rights and make sure that everybody's doing the right thing. So what do you need to do? Well, you've got to post this notice as soon as it is available. It should be on January 1st. We'll get that out as quickly as possible. You want to include it in new hire documentation. So you can't put it in enough places. We want to put it in the handbook as maybe an addendum this year, and then we'll add it the next year if it doesn't come out soon enough. But we want to post it on the wall, want to add it to our new hire documentation somehow. So yeah, this is, and whether that's in the handbook, if you're very sure that your handbook gets out every single time, that's up to you. But this is something that you're going to want to put out. And again, whether the handbook gets updated, that's optional. You can just do it as a notice as part of the new hire packet, or you can just put it in the handbook. That's up to you. So that's probably the biggest actionable item this year, just so you know. The rest are not too difficult to comply with. So let's go beyond this, and we'll get more information, as I said, when this information comes out. Okay, this is another little small thing: personnel files and training records, SB 513. So what changed is that now if an attorney or an employee asks you for personnel records, right? They're typically going to ask for payroll records and personnel records. The training and education records are now part of the personnel file. So sort of benign, not a big deal. Must be produced upon employer request. So if you're doing any kind of training, any kind of education, maybe it's harassment prevention, safety training, maybe it's company training for specific skills in your business, whatever it is, you should be keeping a record of those training events. And if you use our system, our iSolve system, you can upload those right to the employee file. and the employee profile. So that's a really good thing to do. You know where they are. If there's an expiration date on them, you can set an expiration date. And that's a really good way to sort of automate the training retention, training records retention, and then to make sure that you do get them retrained when that's coming up. So this is not a huge thing, but you've got to have a method to track that in the employee file. So just review your record storage process. What are you doing with employee files? If you're still using paper, I hope you're not. We would love to have you guys on onboarding if you're not now. If you're not a client of ours, hopefully whoever you're with, you do have digital onboarding where everything is electronic, it's paperless, and it's all tracked in the employee profile. And then you want to ensure that request timelines are met on any request for records from an employee. Typically that's an attorney. You've got 21 days to get payroll information, timekeeping information, and you got 30 days for personnel records. So just know that that's something they can get you on. I think the fine is like $500 or $750 a day if you don't get those records on time. Okay, next up. Does this affect your handbook? Yeah, it definitely affects your handbook. It should state that you do keep employee records on file, and that they're accessible by the employee or by a third-party designee, typically an attorney. Okay, so the new equal pay expansion. So this is, again, going back to pay equity. Why my clicks don't seem to be working? I got a lot of clicks. Okay, so what changed? Employers must now ensure that any form of compensation is included. So that would include salary and overtime, bonuses and commissions, benefits, stipends, vacation pay. So what that means that when you when you set up a position, like I want to hire this marketing manager, and it's an $80,000 a year position, the benefits are worth $4,000 a year. The potential bonuses are $10,000 a year. Vacation is $5,000 a year. That all has to be taken into consideration. I don't know about posting yet, but as far as that, when you are hiring for somebody, it's all got to be transparent, so that if you're offering this job to one person or advertising the job to one person, you've got to advertise the exact same compensation, or at least a transparent view of that compensation to that employee. And that's where the way that this is going to become a problem is that if you ever got sued for discrimination, and an employee A could prove that, well, I'm the exact same job or the exact same experience, but I don't get as much vacation, or I don't get as much bonus, or I don't get as much stipends, or whatever else it is. That's where it's going to become a problem. So there's not a whole lot you can do about this now, other than to make sure that when you do set up a position within your company, that you know exactly what the pay range is, what the potential benefits are. And what I really recommend everybody do, if you've got, for small companies like us, we've got 4 payroll reps and 1 HR rep and 2 recruiters. I mean, we're pretty small, but if you've got multiple positions in your company, multiple levels of management, you need to be really careful and set up sort of a grid that will show all the positions you have, what the pay ranges are. And what you could do is, like, this is marketing manager 1 and marketing manager 2. So marketing manager 2 is going to require more experience, or more, more education, or whatever that is. And that pay level would be different. So that way, when you do advertise for a job and somebody doesn't qualify for one position, they don't qualify for the manager 2, you can now give them the marketing manager 1 profile and pay. So that's something that you got to be careful at. I think it's something that it's going to become more and more of an issue here in California. Again, a lot of this is driven by lawyers. They're trying to almost, I feel like, and again, this is my opinion, sometimes it comes out, and I apologize for that, but I feel like a lot of this is attorney driven, and they're just making it more difficult for us to comply and easier for them to find ways to file lawsuits. Again, it is great. There should be absolute pay equity amongst anybody that is a like person. The problem stems is when somebody, again, exploits that loophole, or exploits something that you don't have in writing and isn't really clear, and then they turn that into a lawsuit or a settlement demand. So that's what the scary thing about any time that one of these laws come out. So what do you need to do? Your pay equity reviews pay equity reviews are broader. So I don't even know what that even meant. I put that in there, but I'm not sure what I was thinking. But you've really got to review your positions, your pay equity, make sure that it's done, that uh, you understand that anything that's inconsistent between the different positions that you have and the pay ranges for that or whatever the benefits are, it's going to be a higher risk if it's not consistent across the board for every gender, for every race, color, creed, all that stuff. Does this affect your handbook? Yeah, definitely needs to be in the handbook, that you adhere to the pay equity rules. We'll have some language on that in the new handbooks coming out this year. And that's a fairly important one. It affects larger companies more than smaller companies. If you're under 15 employees, you don't have as much of a exposure, but the larger companies do. Okay, this is another sort of big one. Victims time off for victims leave and protected time off, AB 406. So this just means that there's going to be expanded protections for victims of crime, domestic violence, stalking, harassment, and an increased enforcement and retaliation risk. So this is basically saying that if an employee is a victim of crime or domestic abuse, whatever it could be, might it be harassment within your own company, they are allowed protective leave. Now, I don't have the details on all that, but you can't. There's a certain amount of time you cannot fire them, you can't discipline them. They're pretty much protected, and if they use that as it's a CFRA, a California Family Rights Act. If they're using that to take leave, then that is protected. That's another type of leave that's protected. Like right now, it's medical or caring for a family member or baby bonding. This is just another protected type of leave that an employee can take. So what do you need to do? You just need to train managers on protected absences, right? So this is very, very important. This is something where it really comes down to practice, that if an employee requests leave at all, you want to make sure that you respond to that very, very quickly and you take it very seriously. There's a whole bunch of different reasons that some have to do with an accommodation potential, where an employee just says, gosh, I'm having some problems with my back. I can't really move. I can't stand as long. Or gosh, I'm having trouble with my father-in-law. He's in our home and he's not, I've got to come and help my wife out a couple times a week. Those become potential accommodations where you've got to enter into an interactive process with that employee to determine what their accommodations are, right? Do they need a couple times off a week? Can they not stand for so long? But then also when somebody says, hey, I've got to take care of a family member for a couple weeks or 3 weeks or whatever that might be, then you've got to really look into that. You've got to get medical certification. You got to ask them who the family member is, because you've got to know whether or not that is a protected or an included family member within the law. So there's a lot of work that has to be done the minute you hear of somebody that's having difficulty personally with an injury or an illness or anything like that, or they are caring for somebody, or again, now added if they've been a victim of a crime or a victim of some sort of domestic violence or something like that. So we just have to have our ears on every time something happens. That's what we're here for. We really, really want you to call us the minute you know of something, you hear of something going on in your business. Please let us know. Then we can help guide you through the right process that will be documented and compliant, and that will bring you to a good outcome. And that's the key. And this is where I see a lot of things go wrong with leaves. Let me see the last one. Apply leaves consistently. Yeah. One of the big issues with sorry, I need a little bit of coffee. My mouth's dry. One of the big issues with leaves is that employers drag their feet. I hate to say that sounds negative, but they maybe are not as prompt as they need to be in responding to an employee leave request. And if we do the leave notices and tracking for our clients. So if they don't tell us on time and 2-3 weeks go by, then that employee just got a free 2 or 3 weeks of protected leave. And because it doesn't start until they get that notification letter and that acknowledgement letter that starts their leave on that day. So you really got to keep up on this. Again, this is a whole subject that I won't get into right now. We will be getting into this more in the coming year, but yeah, just be aware of it. Okay. Does this impact your handbook? Yeah, absolutely. This will be in the handbook, and we'll have the language for that as well. Okay, this probably doesn't affect too many. Our most of our clients are under 50 employees. Between 3 or 4 and 100 is generally our client range. So this is for the WARN Act, which really federally is over 100 employees. If you have a major layoff or move your business or close your business, you've got to notify folks. But and in California, it's actually 75 employees or more. So there may be some here that you guys have 75 employees, and just something that you have to know. If you lay off 50 or more employees at one time at one site within a 30-day period, or you shut down your plant and you move more than 100 miles away, then you've got to have certain notifications out, right? So you've got to make sure that the employees are notified, and they are given the proper documentation and all that stuff. It's got to be within a certain amount of time. So I don't think it happens too often, but it's just a little tiny change, nuance in the law. But if you do have something like that, just plan ahead, talk to us. This really doesn't impact the handbook very much, so that's not going to be included in there. Again, this is another little tiny thing. You don't really need to do anything about it now unless you fit into that category. So this is another one. If you guys remember PAGA reform and what came out after that, that it basically restricted or reduced some of the potential penalties if you did certain things right. And then if you did certain things wrong, the penalties would be, expanded. So we knew that was probably too good to be true. So this is sort of a reform of the reform, where now if you don't pay those wage judgments, they're sort of adding a layer on top of whatever is there. You could be fined up to 3 times more now than what you could before. So that just means increased enforcement actions. They're trying to get the money from you, and you're going to be paying for it. So hopefully this doesn't ever become part of your workforce events, because we don't want to get there. But yeah, if you don't pay those wage judgments on time, then you could have some problems with that. What do you need to do? We want to respond very quickly to wage complaints or claims, or if you get a PAGA notice, which we've seen multiple PAGA notices lately, you want to respond to that very, very quickly. And the way to stay out of this is absolute wage and hour compliance. That's just critical these days. Timekeeping, meal breaks, rest breaks, final paycheck, final pay after termination. All those things are super, super important, and more so now because the penalties can ruin your business. They can knock you out. Handbook impact. Nope, this doesn't even affect the handbook because it's not really part of that. Okay, another sort of little nuanced thing where it's called bonus clawbacks and repayment limits. This is it's kind of a small one. It's sort of it's called a stay or pay rule, where if you hire somebody and you say, listen, I'm going to give you a retention or a signing bonus of $5,000, but you have to stay for 6 months or a year or 2 years, and then that employee leaves. This is now restricting what you can have repaid on that. I'm not going to go into the details of it because I don't think that happens too much. But it just basically means, like, if any of you pay for training, let's say you say, listen, if you come here, I'm going to pay for you to go get your certificate, but you got to stay with me for 2 years, or you're going to have to pay for that. So this is just putting some limitations on what you can get back from that employee should they leave you before that time is up. So it's not telling you can't do it. It's just restricting what you can claw back from that employee. So this applies to any agreements that are starting next year. Does not apply retroactively. We don't see this too often. It's we have some in our staffing company. We'll do retention bonuses sometimes. If an employee stays for 6 months, they get a little spiff at the end of that, but that's completely different. So not much you need to do unless you are doing these kind of things. And then in that case, you want to reach out to us. but definitely review your offer letters and how you're applying bonuses, signing bonuses if you are still, and then remove something that's unenforceable. So again, we don't have a lot of information on that. That hasn't been detailed legally yet, but we'll have that information soon. And that, does this impact your handbook? No. So very, very simple. Now let's move on to, so that was basically it. So there, as you can see, there's no major, massive sick pay increases and major laws this year, which I think we should be all grateful for. I'm sure they're working on some for next year, but for right now, we've been spared any massive laws that we have to comply with. So now, what's in your handbook? What impacts your employee handbook? Again, we talked about that during the slides, but obviously leaves of absence, protected time off, that's going to be changed. Personnel records, record inspection, that'll be changed. The equal opportunity, pay equity law, there's some things that will go in the handbook for that. And then obviously the required handbook, required notices for the required workplace notices. So that's it. That's really all we have to worry about. Is that's going to really affect written policy or posting. Most of the other stuff is what happens in the background after something happens. So how we can help you, obviously we do annual handbook updates. We're working on it now. If you are one of those clients that has submitted their 2026 handbook update for your own policies, thank you very much for getting that in. We're trying a new system this year to track it. Please be patient. We do a couple hundred handbooks every year, and we try to get that done as quickly as possible at the beginning of the year, but there's always little hiccups and changes. And this year's not too bad because we don't have so much, but when I send this, the recording of this and the slides out, I'm going to send you a link to that. If you have not done that, please fill that out. If you are not a client and you'd like to talk to us about handbooks, and please reach out to us. We can help you with that because we do update these annually. And it's very expensive when you have an attorney or somebody do that. It could be up to $2,000 to $3,000 to have a handbook prepared. We really don't charge that much. Again, we do a very basic handbook plus the legal, all the legal stuff, and we do custom policies for the client. But we probably are not industry specific where you're going to need a lot of specific things in a handbook. We can do it on a limited basis, but we try to get you a very legal handbook that's going to protect you. So yeah, obviously we help you with best HR practices when problems arise. The problem is that we don't sometimes get notified when problems arise, and if we don't know what's happening in the beginning, we have to sort of come in at the end and try to fix it. And I guess that you can liken that by looking at your ceiling, and in fact, I have a leak up here. You know that you've got a leak going on. It's maybe dripping slow, but it's happening and it's getting worse and worse. And then you don't wait to call a roofer until the ceiling caves in. That's very analogous to what's happening with some of the HR issues that I see. So just know that, get some help. If it's not us, get some help from somebody when things go on. And then we can help you to kind of nuance special situations. And this is where I think what sets us apart from a lot of companies is that there's black and there's white, but then it's how do you strategize a response to an employee issue or a difficulty or some sort of a challenge in your business? How do you work around that? Since we've done this so much, and usually the outcome is very good, we can kind of help you through that process. So that's something that we can really help you with. And not trying to sell you guys on Infinium, but I want you to make sure that you know that we're here to help you early on with a situation when it happens. And then obviously ongoing HR compliance as things happen, we want to be able to help you. Okay, so what can you do to make sure that your 2026 is smooth? Let's talk about some steps and some moves that we can make. Again, it's not going to be too difficult here, but first of all, update the handbook. Make sure that your policies are clear and easy to find. Update it, annually, but make sure your managers, you and your employees all know what your policies are. And if you come up with policies during the year that you want to make an adjustment, get an addendum out, get a notice out, make sure everybody knows that, and you can look at it. Because something like attendance, I asked a client the other day. Somebody had been out for 2 days, no call, no show. And I said, well, what is your policy? They said, well, it's 3 days. After 3 days, no call, no show, they can be fired. Okay, so do we need to adjust that to 2? maybe next year, but they knew exactly what it was. I said, well, we can't do anything yet because your policy says, 3 days. So we can't fire somebody in 2 days for that. So it's something you want to just be aware of things like that and make sure that you're up to date. And then actually practice what your handbook says. Again, if that employer would have maybe let that person go for 5 days without with a no call, no show, it could have ended up in a problem. They could have filed a settlement claim or gotten hurt or done something in that period of limbo that could have affected the employer. So make sure that you know exactly what your handbook says and that you act on it when situations arise. It is your guidebook. It really should be your guidebook with attendance, dress code, performance, remote policies, what employees should be doing and how they should communicate. All those things should be in your handbook. And then standardize and automate your hiring and onboarding process. I can't say that enough, to make sure that all these notices, all these policies, everything is consistent with every single hire. And, gone are the days of running a 40-page copy of an employee, a new hire packet. That just takes a lot of time. It's not consistent. Who's going to check everything? Make this part of a digital part of your onboarding process where everything gets signed, everything is tracked, and everything then is stored properly. And the employee cannot proceed through those documents without not signing something. So that's important. Again, timekeeping, enforced meal breaks. We still have a lot of clients that are, haven't really come to the facts that come to the reality that California is a dangerous place to do business in without timekeeping and meal break enforcement. And there's things, the regular rate of pay has now come into play, which is really, it's this little tiny thing where somebody might get an extra $1.42, on their paycheck one week. And if you don't do it right, you could be sued for thousands of dollars. So it really pays you to get that in place. Hopefully you've been on our previous regular rate of pay, our blogs and the webinars we did last year. But that is basically if you pay anything like a bonus, which would be like a discretionary bonus, meaning that there's a reason why that employee got that performance, production, whatever that is, or there's a commission, you have to add that to their weekly pay and come up with an average blended rate and then pay an overtime premium based on that average blended rate. And you also in California need to pay sick time. Now we have a client in Arizona, we have a couple of them, but one of them that you don't have to pay the sick pay there, but you do have to pay the overtime premium. And we had to kind of mix and jumble the way they stacked those bonuses on top of their pay to make sure that was all inclusive and they properly calculated the regular rate of pay. So just know that this is something you can do it very easily. Our system does it automatically. So something you really got to think about if you're not doing it. Deal with performance issues promptly. Do not allow an employee to continue with performance issues that are affecting your business. Small stuff, yeah, that's different. But the mediocrity in an employee can be very detrimental to your business if you allow it to continue. And then you want to try to do something. By the time you have gotten to that point, that employee probably realizes they're not doing the job and could end up causing some trouble because now they're afraid of losing their job. So they're going to find any way to get their hooks into you and make sure it's very difficult to terminate them. I see this on a weekly basis, whether it's a leave issue or an injury or a complaint or a harassment issue, whether true or not, they're going to find a way. So make sure you deal with those issues promptly. Your workplace is a privileged area, right? You should always and only allow folks that are there to do the job well, be there consistently, be there. The attendance, tardiness, all that stuff is under control. Those folks deserve to stay in your company. If they're not adhering to those standards, then you need to take steps to either fix it or move them out and help them to go be somebody else's employee. So that's just something I've got to say that clearly. Promptly deal with any leave requests, as we mentioned. I won't go into that anymore, but that's something you got to be aware of. Manage attendance consistently, right? And correct those excessive absences. We already talked about that a little bit, so I won't go too much into that, but that's super important that you don't allow lazy attendance to continue in your business. That's a bad example. Then everybody thinks that, I don't have to show up. I can just take time off whenever I feel like it. So have a good, strong policy with that. Train managers and wage and hour rules. We were working on this. We used to have an HR 101 training and it was sort of general. We're now working on breaking up the very specific uh, between wage and hour and leave, culture, performance issues with employees. We're breaking that up into multiple training modules. And we're going to be able to sign new managers or employers up or new clients up with a series of videos that they'll be able to read, be able to take an exam, get a certificate for. We want to make sure that everybody that is managing in your business knows these steps. That's something that we're working on really hard this year to get that out. So keep a lookout for that. We'll probably start with one or two of the modules first, and then release more as they go, because it's very time consuming. We're not a big, huge company here, so we don't have 14 people in cubicles to produce this stuff. Okay, so then standardize your company's positions and pay rates. That's the pay equity law. Make sure that you know what everybody, each position should have its own little set of rules and pay ranges and all that stuff around it. Make sure that is clarified. It's almost like an org chart, right? You got an org chart in your business, you know where everybody lands. Make sure that each one of those positions has its own profile attached to it, that you're not just hiring people and creating new positions as you go. That's where you're going to get into trouble. And then periodically audit your wage and hour practices and records. I think every, even if it's only twice a year, this is something that we've talked about in the PAGA reform, is that if you were doing this proactively and you're documenting, hey, we went through and we reviewed our time cards, we corrected these 2 or 3 mistakes, and we paid somebody a meal break violation or fixed their regular rate of pay issue, and we do this maybe twice a year, a couple times a year, then you can now document that. And should you ever get sued, you can show, hey, we do this every 6 months. We're in between, these periodic reviews right now. We hadn't caught this yet, but we're going to fix it right away and it's done. That's how you prevent having a small problem become a big problem. So that's something to really, really think about. And if you need us to help you review, we do have an HR review process that we can go through and ask you some questions. We do that over a Zoom call. Okay, so what if you do everything right? If we're a deliberate employer and we really take this stuff seriously, how is it going to help us? Well, fewer surprises. I hate surprises. And a lot of times when we hear issues with employees, when our clients call and say, "Oh my gosh, I'm having this problem with this employee," I guarantee that it didn't just pop up. It's not a surprise. It's probably something that has been brewing for a while. And it's built up and it just wasn't taken care of properly. And no fault to our employers. Listen, we are all busy running our business. We can't be HR managers. And if you guys know our basic client base, or maybe some HR people on the call today, but most of our clients do not have somebody qualified in HR in-house, right? It's the owner, a couple of managers, 5, 10, 20 employees. We're all trying to run our business. We're trying to just make money, support our families, support our employees. We just don't have time to try to navigate every single law that California comes out. So what happens is that we sort of we miss something along the way, and then it brews and it gets bigger. And that's why I say you'll have fewer surprises, but those surprises aren't really surprises all the time because they've been brewing. Definitely fewer complaints. If everything is right and everything is fair across the board and there's no discrimination going on, there's no lack of clarity with your policies or your practices, then you're going to have fewer employee complaints, and that's going to really, really help out with better culture and better employee retention. And then when you do have problems, we can resolve them quickly. If somebody has stepped outside the boundaries of standards in the company, okay, we know exactly what to do because we've got our standards in place. But if we just have lackadaisical policy or no policy at all, then we don't even know there's a problem. If we can't identify the problem, then we really don't know how to react to it. So that's important to have that. And then we close those loopholes. Again, you can't close it 100%. There's just I've never seen an employer in the world, not even us, and we know this stuff. You can't close all the loopholes. And attorneys, they spend hours pouring through timekeeping records and personnel records, and they're going to find something, or an employee is going to find something in your business that they can sort of take advantage of. So you can't do that, but you can mitigate that risk quite a bit by doing the things that you need to do and doing them right. And then obviously this toxic terminations no longer occur. I can't tell you how many clients we have that it seems like every termination is toxic. There's just a problem. They have to come in here to drop their equipment off or pick their last check up because they can't even go to the employer. They don't want to, or the employer doesn't want them there. That's a sign that something's wrong. And forgive me if anybody's on the call that's facing a lot of these. I mean, once in a while you might have one, but generally, if there's a lot of toxic terminations, then something needs to be fixed, something needs to be changed. It's not always the employee's fault. If you get one once in a while, yeah, that's probably the employee took advantage of you, but we want to limit those. And then your manager should have the confidence they need to lead, right? If they're knowledgeable, they know how to lead, they know how to manage people, deal with performance, and they know the policies of your company and something about wage and hour, then now they're going to have confidence and they can sort of make those decisions at the lower end for you on your behalf. Without that won't get you in trouble. But if they don't know and they're just kind of flailing out there, then you're going to, they're not going to have the confidence, and they're probably going to ignore something that happened or that's happening, and either ignore it because they don't know what to do, or they don't even know that it's wrong. They don't even know that it's an issue. So very, very important to have your managers trained, and we can help you with a lot of that. And then more productive employees. If everybody's happy and culture's going good, then our employees are productive. They want to be here. They want to be part of our workforce because we're a serious employer. We're not just a, mom and pop shop that sort of makes up the rules as we go and shoots from the hip. So very important. And then obviously we have more time spent running our business. That's what's important. We have to focus on these things. We cannot ignore them. The HR rules and the labor laws, we cannot ignore them. We have to put them in place, and so we can run our business. But we're going to spend some time on it. But I guarantee if we don't do things right, we're going to spend a lot more time on it, putting out fires. Okay, so final thoughts on this. About 9:45, I'm going to let you guys out here fairly quick. So going into 2026, California compliance, it really isn't, never has been really about just having some policies in place and getting a handbook. I used to laugh, and no offense to our competitors, ADP, but I used to see clients that would have a handbook from ADP, and it was this little tiny binder about that big, 6x8 maybe, 3-ring binder with about 15 pages in there that were just some legal mumbo jumbo that sort of, tracked all the laws that were there, but it wasn't customized. It had nothing to do with the company. There was no culture statement or mission statement or values, or there was nothing in there that identified that as the company's guidebook. It was just here's the bottom dollar that you need, right? So a lot of companies got along with that for a long time, but now you can't. You really have to be serious about creating your culture and your workplace rules, regulations, standards, and make sure that folks that come in can fit that. All of your policies, your practices, your payroll, everything has to align, okay? So if managers don't know your laws, your rules, or your standards, then they're going to be doing something over here that may not really align with the intention of your company. So that's why it's super important to have your managers trained and know the handbook, and they're not just signing off on it. They know it, they read it, and they refer to it when there's an issue, because that's the first place you should go. Hey, is this in the handbook? Do we have a policy for this? If we don't have one and a weird issue happened, then that manager needs to communicate to the owner or higher ups to, hey, we got a problem here. We got, people are doing this or something's, we don't have a policy for it. Same thing with standard operating procedures, right? If we have a process in our company that just sort of people do whatever they want to get the process done, we don't have a standard operating procedure. So we got to put those in place to help our companies do things right. And then proactive reviews reduce the risk and costly issues. Now, these are reviews that I think they're both performance reviews, but also reviews of your company policy and your practice, right? If we can do this and make sure that things are going well, maybe a once a year policy review toward, like right now, we sent out our little update notice. That should be a trigger for a company to say, hey, let's sit down and let's talk about how this year went, what went wrong, what went right, what kind of policies can we put in place? Can we redo our culture and values statement or whatever it is, or dress code? Does somebody take advantage of it this year? Whatever we need to do a review once in a while to make sure that things are right. And that preparation, that time spent is going to be very, very valuable, because it's way better of having that in place ahead of time than trying to react to something that goes wrong because we didn't have something. Again, this is all common sense. I don't think I'm not a rocket science here, but this is all just common sense stuff. And you don't have to navigate this alone. Again, there is nobody on the planet that I know of, or in the small business world, that knows everything about labor law. Not even me. And I eat this stuff up every single day. Well, I have to go check. I have to research once in a while. We have to, and we have to look into it. But we're here to help. So when you do have a problem, please call us. Please contact us. We have our, I'm going to send this out in the email. We have our new HR support email. It goes to one place. We've got a team of folks that will read those. And we also have a text number that you can text questions to us. So I'll also have that in the follow-up email. But definitely call us when you believe there's a problem. And so thank you for joining us today. I'm really appreciative that every time I see a group of folks that come out to these webinars, we hope that you got something valuable out of it. And if we can help you in any ways at all, if you're not a client or you're a payroll client, but you haven't taken on our HR, please consider that, all the things that we do. Obviously, we also do, as we've spoken before, we do outsourced recruiting. So we have two amazing recruiters here that can help you hire the right person and really weed out those that might cause you some trouble. And finally, on this note, I don't have any events scheduled next year. So I would greatly appreciate if you can reply to the email that we send out. If you have any ideas on anything that you would like to see us do a webinar on next year, please shoot those suggestions to us. We'd greatly appreciate it. And I didn't reach out for questions. Does anybody have any questions? I didn't see anything come across the chat. I'll take a look, but if there's any questions or comments, please put them in the Q&A. I would love to hear that. If not, I will let y'all go. Have a very nice Christmas and have a very nice New Year. I pray that everybody will be safe and you can enjoy some time with your families. We are shut down Thursday, Friday, both weeks, but we will have somebody monitoring emails on a Friday after Christmas and New Year. So if you have an issue that day, and you can always text our HR support line, we can get to you right away there as well. Okay. Thank you guys very much. God bless. Talk to you next time.